Oh yeah, let's start recording now. Okay, we're recording now.
Well, on the Skype call today with Hana Miyamoto. Hana Miyamoto's a lawyer. She studied the law. She studied international law, and she loves California and has lived here for a while. Recently, the American government have appointed Amy Coney Barrett, or Comey Barrett, as the Supreme Court justice, now making the federal Supreme Court majority conservative to a level not seen since, well, about 50 years ago. A lot of people in California are disturbed with the announcement of the new Supreme Court justice. Many Californians who are not Calexit supporters have started talking on social media about secession. So obviously, there's a lot of concern in California about this appointment. So we thought we would talk to someone with a legal background who loves California and is deeply concerned about the loss of our values. Hana Miyamoto, why should Californians be concerned about the court turning majority conservative at the highest levels? What does that mean for us? And why is it a real issue that's worthy of us actually getting quite worked up and upset about, in your opinion?
Well, the first thing is, of course, is the fact that the procedure wasn't followed, and that the Republicans insisted on appointing or confirming Barrett, even though they had previously, even though just a few Barrett with just a few days before the election, even though they had refused to even consider Merrick Garland when Obama appointed him to the court before the 2016 election, but months before the 2016 election. So there was complete hypocrisy. That is a disturbing thing, of course, because it really shows a Republican leadership that is totally focused on just doing, on just doing anything to enhance or increase their power or their sense of power. There's also the question of why was there this rush to go and put her on right now? Because she was confirmed. I believe she was confirmed today, from what I read. So confirmed and sworn in. So she's on the court as we speak. Why did they do this? And you have to believe it's because of a need. Two reasons. One, to be on the court when the Trump administration case to declare that the American with Care Act, the ACA, the Health Care Act, will be reviewed. The Trump administration position is that the whole act should be must be declared unconstitutional and without severability, without the ability to basically save any portion of it. And the other piece, and I feel that's even more, and that, of course, that first part, of course, has been what the Democrats have emphasized constantly, because they know that healthcare and preserving access to healthcare is something that voters have no trouble absorbing as a piece of, as something insignificant to their lives and their families' lives. But then there's the election, and the fact that putting Barrett on the court now guarantees that she will be able to influence decisions concerning which votes are counted, which votes are considered invalid, when does voting stop. It could even go down to the question of which electors are appointed. What happens if the governor appoints a set of a governor appoints a bunch of electors, and then the state legislature of a different part will control a different party appoints another set of legislators, and on and on and on. And it shows that they really feel like they want a thumb on the scale, because they already had a majority if you included Chief Justice Roberts, but they seem to feel that Chief Justice Rogers is not reliable enough to be a rubber stamp for them. We might add that as we speak today, there's a lot of concern because Kavanaugh, I don't like to call him a justice, Kavanaugh was issued a concurrence in the case involving Wisconsin's voting, in which he stated that states had an interest to, as he said, declare the result of the election by election day or as soon thereafter, possible thereafter. And of course, it's Donald Trump's position that all votes should be counted on election day, and then after that, we should have no more counting after that. That position, of course, has no foundation in the law. Not a single state follows that law, to my knowledge. No state follows that law, and it's physically impossible to actually count all the votes in any state. Nevertheless, and this is the great concern, that this is one of those fake controversies the Republicans and the MAGA crowd and the Proud Boys and who knows else is going to use as justification to initiate armed conflict in the United States, or who knows what, and the grounds that because they're going to claim that the election's being stolen because rules that have never existed before are not being followed.
So just to summarize for everybody who's not a professional legal background scholar, it's not coincidental that Amy is being appointed to the court right before the election. So if there's any chaos with the election and there's any disputes by how votes are counted at any of the states, that can get kicked up to the Supreme Court, where now you have a bunch of Trump backing Supreme Court justices making rulings probably in favor of Trump. And so that's
it'll be a 5-4 majority.
Right.
The hope is that it'll be a 5-4 majority, and that'll be enough to achieve whatever goal that they want. That's basically saying that Chief Justice Roberts, remember, the fact that he tends to vote in the middle between the liberal and the conservative bloc, that the Chief Justice Roberts' viewpoints are not valid.
Well, I could certainly see
that's basically how I interpret that. That's basically what the Republicans are saying. They've gone this far. They've gone down this road. They've been told not to do it. They've been warned and warned and warned. They now have, they have in fact obliterated the legitimacy of the Supreme Court, and they've certainly basically said that as far as we're concerned as Republicans, the opinion of Justice Roberts is not a valid one, or not one we want to hear.
And so you have a majority conservatives on the court. They're political. They're not strictly independent of opinions. They're going to side for Trump and give him the election through a series of decisions.
And I say not judges. I mean, they're not. They do not. None of them have. None of those 5 have the judicial temperament. They are doctrinaire. They are not going to decide these very important cases with attention to what the law actually is and says. They're not going to have any respect for the legal traditions of this country. They're not going to have any respect for the Constitution that I swore an oath to uphold 3 times in my life.
And as we saw,
I'm sure I'm not the only lawyer who says, I do want to remind you that when we say not judicial, when I say not judges, and that may seem so extreme because you're saying, well, they're judges, they have the power of a judge. Yes, but to us lawyers, we talk about judicial temperament. We talk about, a fairness, an objectivity, a respect for the law, respect for precedent, respect for principles, respect ultimately for the people of the United States of America, the voters, respect for the fact this is a democracy in which the popular will is what governs. And the only reason why the popular will would not be defied, will not be upheld, is only because the rights of a minority are in fact substantial enough to be protected by the law.
And to let everybody know that this is not a thing that you shouldn't actually be horrified about, I would remind them that in the year 2000, there was a disputed election and the Supreme Court stepped in and picked the president, which shocked everyone. So this could happen again, and it
Yeah,
won't be the will of the people.
right. And or it will not be right. I think I like to say one other thing though, which has the question of California's policies, and this is what I want to talk about
Yes. Yes. Let's get into that. How does
because
let's go past the election, regardless of whatever happens. How do we lose our rights? You were telling me about a plan by Trump, no matter what happens, to replace Supreme Court justices, circuit courts, lower federal courts, so
no,
that it's
I
all
was
conservative judges all the way through, and all of our California laws get shut down.
well. Actually, I said they have already basically have already done that already. Um,
That's
because
terrible.
because well, because you got to understand. Because when Obama was president, the Republicans refused to to fill judgeships as they opened. We wound up with a huge number of judges, I believe around 100 federal judges that were not um, appointed. And in the last 4 years, a whole bunch of these, they've all been refilled to the point of now today, 1/4 of the federal judiciary is now appointed by Trump. And then that's, of course, that's neither here nor there, as much as the fact that um, before Trump, federal judges tended to were evaluated by the American Bar Association, by a special committee of the American Bar Association, which generally judged whether judges were qualified or not qualified or less than, well, whatever, I don't remember the terms, but they were, American Bar Association, of course, is the largest legal organization in the United States of America. It represents the views of the vast majority of lawyers, and especially, frankly, the lawyers in the big firms, the lawyers who are most prestigious. And the ABA, what happened was an organization that most Americans have never heard of called the Federalist Society.
Yes.
Right. It's. I mean, I knew it very well as a law when I was a young law student. It was because it's the conservative lawyers group. And they have a viewpoint. They're heavily funded by corporate interests. And basically, I would think that if a lawyer had absolutely no scruples whatsoever, if they were a young lawyer, they wanted to go to law school and they had no scruples whatsoever and had no viewpoints other than just their own sheer ambition, I recommend they join the Federalist Society and then absorb whatever claptrap that they're promoting over there. Um, because what's happened is it's become like a recruitment system for the federal courts. They get people, they make sure that their mindset is so doctrinaire in one direction and their biases are so strong, and then they just elevate them up through the federal court system. And of course, with the ability to put 1/4 of the federal judges on, the we're in a situation now, and again, where these are all lifetime appointments. You become a judge at the age of 40, 35. I think there are some 40-year-old federal judges now under Trump who Trump has appointed. Those people are going to be there for at least 30 years, most likely. They might be there for 40 years. It's not unreasonable for a judge to be emeritus and a retired status, but then they call them in so you could still be hearing cases when you're in your 80s. And but at least they had their mandatory retirement. I think is 72 for federal judges. So, anyways, these people will be there for a long, long time. And they can't be removed except through the impeachment process, which we've already found out requires a 2/3. They're just like the President of the United States. You have to have 2/3 of vote in the Senate. You have to go through a trial in the House. It's a whole thing.
So let me summarize for the non-lawyers what I think I'm hearing. Historically, there were conservatives and liberals, but they would pick lawyers from the American Bar Association, and the American Bar Association would say, okay, these people have passed some sort of benchmark that we agree is reasonable to be a judge. Trump threw all that out, went
McConnell.
to a hardcore ideologue group that's, here's the mainstream group, and they've had Republicans and liberals, and maybe they don't always agree, but they have some sort of standard on what's competent. That's gone. He went with this total fringe movement group and said, we're going to start picking all our judges from there. And he's managed to replace up to a fourth of the total federal judges from this hardcore group. And what you're saying is, this is a totally different group. They're hardcore ideologues. This is a huge giveaway that they are. He's managed to put a lot of these people in, and it's damn near just basically can't be done to get them out of office once you got them in. Is that a roughly correct summary of what you're saying?
Well, right, unless Congress unless the Democrats take power and then use their full power to change that, but not through that. And and I would not actually do it through the impeachment process. I've said I just suggest abolishing their courts, but it would take something really radical as that to abolish all the courts and then appoint all new judges all over again.
Okay.
Again, but then of course you have the next question of whether or not that's going to be deemed unconstitutional, and who knows? And then basically they're creating a constitutional crisis. But actually, it goes worse than that, because it's not just that they're Federalist Society members, but also the fact that that's actually McConnell made that decision to start doing this basically. Also, because after all, under our tradition, it's not the Constitution of the United States, by the way. It just says it doesn't actually require. There's nothing that specifically says the Senate has to confirm a judge. It just says with advice and consent. So it's been interpreted as though it has to be as a mandatory confirmation. So okay, but we honor that tradition. Then it's interpreted as such. Then okay, fine. The next problem is that sorry. Of course. The fact that previously there was a system whereby they consulted with the senator from the state that judge would be part of.
Right. And Trump removed that tradition.
McConnell did.
With California, replacing conservatives on the Ninth Circuit Court, which rules us here in Cali. Am I remembering correctly?
That's exactly what it is. Basically, the judges that are being appointed to serve in Texas or Alabama or Georgia or Kentucky or West Virginia are the same cloth as are representing us, who are now judging our cases in California.
What really disturbs me is that you have, I think, 12 circuit courts, right? So there's so many circuit courts. States pass laws. There's a federal court that, there's 50 states, and there's so many circuit courts, like 12-ish, something like that.
I think I'd probably want to say 12, because there's the DC circuit. I think it's 11 Circuit Court of Appeals, and then the DC can't be ignored either. But there's actually a lot of other federal courts too. Court of Claims, tax court, etc.
You got so many states. The states pass laws. But then there's these federal courts over them that can go, well, that's actually illegal. It bumps up against the Constitution, federal law, and they can strike down state laws. Now, for the last 30 years, the Ninth Circuit Court was the federal court over California. And it had the highest number of cases overturned of any circuit court outside of the one in DC. Which means if you got 12 circuits, the federal government's passing laws, and then you got the circuit court over the federal government going, I'm not sure about that, I'm not sure about this. And then you have California.
I'm so sorry. My mother needs me. What is it, Mother? Yes, I'm not going to be on this very long. I'm sorry, America. Sorry, California.
So then you got the Ninth Circuit. And historically, we had a huge amount of our laws overturned anyways when that court was a fair balance of conservatives and liberals. And now the Ninth Circuit's turning to mostly conservatives. So am I wrong assuming that we're going to have all sorts of California laws struck down by the Ninth Circuit? And then if we appeal them, it's going to go to the Supreme Court, who's either not going to take the cases or back up the now conservative Ninth Circuit, because the Supreme Court itself is now majority conservative.
Maybe I could put it this way. First thing I should tell you that actually the Ninth Circuit has been the circuit of California for much longer than 30 years. It's only back in the last 30 years that the high court's been conservative enough that it's been a issue with the Ninth. I mean,
Thank
take
you.
take Miranda versus California. That's the famous, you have a right, you have the right to remain silent. Anything you say can be used against you in a court of law. The famous
Yeah,
cop show case that we all know and love. That's an
yeah.
example of a Ninth Circuit Court decision, which was upheld by the United States Supreme Court back in, I think, oh God, 54, please. Sorry, California. I have not practiced criminal law. Okay. But I think it's 54.
But
So,
yeah.
anyways, yeah, it was, or Gideon versus Wainwright. That's another case involved. That's the case that says that's more lesser known, although Henry Fonda was in a movie about it where he starred as Gideon, which said that you have the right to effective counsel in a criminal trial. So, so those are Ninth Circuit decisions which were upheld by the Supreme Court of the United States, and thus that at this point today, on the 27th of October, 2020, they are the law of the land. Smile. But what I'm saying is that at this point, you understand, even with a Supreme Court that's conservative, remember the Supreme Court of the United States only hears 200 some cases a year. So the idea had been that with a liberal Ninth Circuit and a liberal District Court of California, by the way, you would decide. Of course, there's the Ninth, and I know there's different district courts. There's a northern and a southern, and whatever. Doesn't matter. There's district courts in California, and then you got the United States. You got the Ninth Circuit Court of Appeals. And the idea being that you might get your district court case, and maybe it got appealed, and then it'd be upheld. And then it would never get to the Supreme Court because the Supreme Court wouldn't what we call grant a petition of certiorari. It means they wouldn't hear the case in the Ninth, and therefore there'd be the law of the land. Law for us, at least.
Right.
I guess an example of that might be the Prop 8 case. That's Hollingworth. I want to say, oh God, I can't remember. It's a Hollingworth case where where it was decided in favor of same-sex couples in the Ninth, and then it was appealed again to the Supreme Court of the United States, but then it was upheld. I think that's what happened. I can't say. I think it was upheld. I think it was the Ninth that was favorable to it. Anyways, I should probably just shut up about it. Just in general, that's the idea. You take it up to district, it gets through, you win, great. It gets appealed, you go to the Ninth rules on it, okay, and then it would never get to the Supreme Court, and therefore that's good enough, okay? But when you get a whole bunch of Federalist Society judges sitting at the District Court of California and the Ninth Circuit Court of Appeals and the Supreme Court of the United States, it makes it very difficult. And again, a conservative legal viewpoint is one thing. A doctrinaire viewpoint, which totally ignores the law, is another. Or I should say totally ignores. In my years of practice, I've always hated laws where the reasoning in one case doesn't seem to apply to a very similar case in another example. In other words, there's a break. The one problem with that is, this is theoretically speaking, is because suddenly who wins starts depending on which category a case falls under. You know what I'm saying?
Yeah.
You wouldn't want a situation where the law goes one way if it involves a car, but the law goes a different way if the law involves a truck. Because to you and I, a car and a truck are the same thing. They're a motor vehicle. Okay, and then what would be an SUV? Would be a truck, it'd be a car. You know what I'm trying to say? We don't like that, so we want general rules that apply in all cases. I want an example of what the Prop 63 case, I think, is an example of this. Maybe it's a little long, but we got some time. I'll explain to you, the same to California, what's been going on with Prop 63, if you don't mind. Prop 63, if you remember voting for it or voting against it in 2016, among other things, declared that you couldn't have a magazine on a gun that in California that had more than 10 rounds. Okay. In 2019, the District Court of California declared that to be unconstitutional. In August of this year, the Ninth Circuit panel, 3 judges of the panel of the Ninth Circuit Court of Appeals ruled 2-1, I believe, that it was unconstitutional. And the state of California has now appealed it again, and hoping for a favorable decision, what we call the en banc, which is where you get all, I believe, 29 justices of judges of the Ninth Circuit Court of Appeals, and that goes. But I will tell you that I did look at the case, and I think that I guess my opinion as a legal expert. It's my opinion that I think California is going to lose. And I think the reason is going to, but I don't think they should lose, but they are going to lose. And here's why they're going to lose.